Hey, good afternoon, everybody. This topic of merger control is very much like this session. You realize that it's taken that you need to go for a merger filing quite late. So we were supposed to end the session at 1:15 rather than starting it. You don't realize where the time has gone, and you're very impatient because merger control comes in the way of lunch, which is consummation of your transaction. So this is in a nutshell the impact of merger control on deals. And we have this great panel here, which is Dominique from Raja and Tan from Singapore, and Dr. Ghemawat from Dalmia, and of course Shashank, who is a partner at PNL offices. So the purpose of this panel is to really understand how merger control can impact deal timings, deal structures. In the last panel, there was a lot of talk about compliance and how compliance can ensure sort of reduction in penalties for cartels and for in general reputations and risks that come in for companies. But one of the most important things as part of as our practice of competition law when we're looking at compliance is also to see, did a sneaky deal get in the way which everybody forgot to notify, and will our client have a reputational risk because of it, because they're going to be filed not only by the Indian authority but also authorities elsewhere. So those are important risks. But as we will go through in the course of this panel is also to realize that how sometimes that what the intention, the deal intention was when they were entered into, what was thought in terms of timing, what was thought in terms of what they were going to achieve may actually change in the course because of regulatory risks. And sometimes the regulatory risks may not be obvious for anybody, and they may have just an aggressive regulator which will come in and want to know details about your transactions. Just to give a current war story that we're currently dealing with, we have a company which was in pre-insolvency. The banks had made it very clear that if the CCI approval does not come through before 31st March, they will push the company into insolvency. The CCI currently, for the last 1 week, does not have a quorum. Our chairman is in Germany, and one of the members has a family wedding to attend. So as a consequence, the approval is stuck, and with Holi next week, we don't see the approvals coming in before 31st March. As a consequence, yesterday, the State Bank of India filed a bankruptcy petition against our client in NCLT in Calcutta, and now we're challenging that by way of a writ petition. So this is the way deals can get affected in our country, and I'm sure that is the case. So without further ado, I am going to hand it over first to Dr. Ghemawat to sort of talk about, because we're just talking about insolvency and IBC here. You've been the trailblazer in terms of sort of the first deal which was filed in an insolvency scenario, as well as getting approved. And at that time, there was a lot of debate whether or not that filing was itself premature, whether it was correct or not. So if you could just take us through from at that point and what you thought in terms of getting the transaction and making sure the COC, the creditor committee, looked at it in the right way. Dr. Kumar.
Good afternoon, friends. Absolutely my pleasure to be here. Karan asked me a very broad question, and well, all the players in the market today in the industry, they are quite aware about the way in which the industry is moving and how the players are moving. So any acquisition, whether of course IBC is a recent phenomena, but then any acquisition, almost all industry players, they do their homework properly. So why they go for acquisition mainly? And obviously there are only two objectives why they go for those kinds of acquisitions, and I think that would give the perspective. One is that they look for some incremental value out of that acquisition, and that incremental value can be anything. That can be revenue, that can be profits, that can be market share, that can be enhancement, that can be vertical integration, that can be horizontal integration. There can be there can be multiple reasons, but there would definitely be an incremental value of an acquisition. And the second aspect is there should be that incremental value, or that acquisition should have some sort of synergy with your existing operations or your existing way of functioning. Now, if these two things are there, you go for acquisitions. Now, in situations where we know that the properties are under IBC, of course, there are some difficulties, and that is exactly the reason why those properties are in difficult shape. So now, as far as the groundwork part is concerned, all industry players, irrespective of whether that property is in the market or not, they do their homework in advance for all markets. And we know at a given point of time in which all markets what is existing and what is the situation like, what would be the future scenario, etc. So it's an ongoing kind of a study which all organizations do, and almost all industries. Of course, right now I'm representing cement industry, but then I was earlier with the real estate industry. So all industries, they do their homework as far as that incremental value or the synergy part is concerned. Then the people look for opportunities, that where we get the opportunity, we will explore those kinds of opportunities. Now, while exploring opportunities, there are some hurdles and some obstacles. Those are very obvious, and I will just first give you as you mentioned about the insolvency related cases. There was 3 cement assets which came in insolvency. And for all the 3 assets, of course, we are the first successful bidder and first acquirer of the first cement assets, which was cement assets, say 70 years old plant, and which was called Kalyanpur Cement, which was in Bihar, and of course that was founded by none other than the elder brother of Netaji Subhash Chandra Bose. So we acquired that plant. Then there are, of course, there's another plant in Morli in Maharashtra, and the Binani, everybody knows about that plant as well, where we had a series of litigations and all that. Now, as regards regulators are concerned, and specifically if I talk about CCI, in a normal situation, we all know as industry players and with the help of our consultants and advisors that what CCI would be looking for as far as assessment is concerned. And traditionally CCI is only looking for the market share or the relevant market kind of concepts, and based on those concepts, they determine this. So what is required in terms of that presentation of whenever you file an application is that you make out your case in such a fashion that you are not making any, you are not taking any action which is leading to any adverse effect as far as competition is concerned. And you make sure as far as your filings are concerned and you are successful. For example, in Binani case, of course, we were not declared as a successful bidder. Before that also, we have filed our application as far as the approval from CCI is concerned, and we got the approval for the simple reason, of course, that there was no adverse impact effect as far as competition is concerned. But then also in that market, we were not present earlier. Just to answer this, that yes, broadly we all know what markets are, how the regulatory bodies would be evaluating or assessing the proposals, and based on that we present our case. Now, there are always so many other things also which comes into picture, and I can dwell upon that if your first round is complete. There are issues also post IBC as well, and those are all question marks. Whatever you file as far as your resolution plan is concerned, perhaps the number of agencies which are involved as far as that successful completion is concerned, they are not bothered about that resolution. The state governments, the local bodies, the workers, the unions, etc. They are not bothered about what resolution plan has been approved, what resolution plan you are following, etc. They would always be talking about their own issues, and there lies the problem. Including litigation, I would say that even the courts are not bothered, that whatever has been finalized as far as the resolution plan is concerned, Courts are finally not, they are not bothered. If some litigations are going on, workers-related litigations are going on, court would always be forcing the acquirer to pay some additional amount or extra amount as far as those litigations are concerned. So those are, other aspects of it. And if I can just briefly, give the industry perspective, that industry always undergoes in, face two extreme kind of situation. One is the sadist bureaucracy, which always thinks that the industry is wrong, they are only here to make profits. And the other part is the socialist judiciary, which always think and always give judgments or orders based on equity. They are not looking for the contracts, or they are not looking for the commercial understanding. So in between, that industry suffers undoubtedly, but then industry also realizes that it's all part of the process, and we accept the reality.
Thank you, Dr. Kumar. Now, in terms of Shashank, merger control tends to be quite process-driven, and at least earlier on, in 2011, when merger control came into India, there was a lot of talk, a lot of missed filings. And at the same time, there was a feeling that maybe it's not for everybody and it doesn't need to be done. So it would come out at very late towards the CP list, in the conditions precedence list during the course of a transaction. So as a practitioner, what sort of practical insights would you see to how to mitigate the risk in terms of both in terms of timing and in ensuring that wherever you need to notify, you are looking at those jurisdictions?
Practically, when I also do some M&A practice as part of my advisory in firm, and have been doing it for some time. And when initially I used to see, before the merger regulation came, it was nowhere in the picture because, of course, that regime is not there. Even after it came, the competition lawyers were the last one to come in the boardroom because they thought that it is just a way of check the box. We'll file it as and when your tax considerations, your business diligence, your documentation is done, and then we'll bring competition lawyer. But over the year, now it is 8th year of combination regulation, and we do see sensitivity around corporates and in-house departments where they are concerned about the risk of what combination filing and everything is concerned, because they start thinking that when they are acquiring, and if it is really a concentrated market, what should they do, how they can mitigate that risk about the filing, because they are on the paper perfect, like their finances are lined up, tax structurings are done, their reps and warranties and SPA is all sorted out. But the CCI can take forever because they are not convinced about your case. They don't feel that the synergies that you are sort of claiming, which will outweigh anti-competitive effect of any merger, and which any merger for that matter will have some sort of restriction, some sort of anti-competitive effect. The efficiencies don't far outweigh those anti-competitive effect. And lately, these have become, it's just not lawyers. A lot of agencies are involved in many contentious cases. It is economists who will be involved. It will also be your financial advisors, your business team who will be involved. And as I see, your merger filing has 3 broad risk items, which you should always try to address whenever you are doing a deal. If it is a clear deal in the sense that you don't, the market has like 8 or 9 players, then it may not be a concern. 9th player buying out 8th player, still you have enough competition in market. But if you are in a really concentrated market, then you should start thinking out in at least these 3-4 buckets. One, I would say, is your actual investigation risk or inquiry risk when you make a notification to the CCI. Then the investigation may go for months, and they can ask various documentation relating to your business operations, management, control, and all sort of a thing. And you should know what you are going to provide. I practically many a time see, and then you would have also seen that in the combination filing, you will be always asked for, give me the board presentations. Many a times the board presentation is there, but they don't want to share because it reflects the true intention of the acquisition in which you are not very comfortable sharing. So of course, if you share those kind of documentation, it entails a huge risk for you because it can be used by competition authority for some other investigation or by any other agencies. The second risk is the substantive risk where, if there are only two players in the market and number one is buying number two, be assured that competition authority will come heavy on you and may stop the deal, like various deals that we have been hearing lately in February, which is again to rail companies in EU, and the authorities have stopped that. So that I'll say complete outlier. We haven't seen those kind of cases in India. The third cases are where it goes to phase 2 and you decide about the divestitures, what kind of remedies you are going to offer, because you really want to do the deal, and you want to do the deal at what cost. You should start thinking about the cost which you are going to bear as part of getting that deal. And in the divestitures, there can be so many aspects that has to be seen, and perhaps in the later part of our presentation we can think about it. But what I am seeing is, in terms of change, yes, people are thinking about competition law. In the CP list, it is not the item number second last. It is I would say in the first 5, and the discussions are happening around that. Risk is also in terms of what Sir was also trying to explain, is also in terms of certainty. Many a times it just, you don't have a clear definition of market. You don't know as to, what sort of a market share is going to trigger any problem. So all those issues are also quite relevant. And only with the help of, looking through cases, interacting with the CCI, talking to practitioners, that you would realize that what the risks are and what you should be careful in your deal documentation. Like lately we have been hearing that a lot of deal was happening where you had breakup fees because the seller wanted to be assured that though you are doing this multi-billion-dollar deal, but if it falls through, then it is going to adversely impact my business. So they were trying to do a breakup fee scenario. Now, breakup fee was a very new animal to CCI. It sets a wrong incentive to CCI, saying that not just I have a control, there is a different control also working on you, and why you are giving this sort of outrageous breakup fees. So, it may be very usual, normal in developed M&A and competition jurisdiction, but it was very new for the CCI to see. So all these are risks. Nevertheless, it is growing, 8th, 9th year, and they have done quite a fair job. We haven't had any deal blocks as of yet, but a lot of ground to cover so far.
Thank you. Dominique, your practice is more international, looking at, there are about 130 plus countries which now have merger control in various forms and various thresholds. So from looking at now as Indian companies are more look at the world as a market, even pure domestic deals. We are advising on a transaction which has had a Bulgarian filing, even though it was a pure domestic transaction. So how do you advise clients, and especially from your experience of dealing with it from more mature jurisdictions to relatively jurisdictions who have merger control only a couple of years old, how do you advise clients on dealing with various different jurisdictions and different standards?
Okay, thank you. I just want to go back to a few points that were made previously. We're talking about the business people. They are very excited about a deal that ticks a tax box, the finance box, of course the business case, and the competition box comes at the very, very end. And actually it should be at the tax level because the financial impact of competition law on a deal can be very, very substantive. That's one. The second thing is that a lot of, in the ASEAN jurisdiction where I am now, merger control is fairly new in many of these jurisdictions. And when you talk to the GCs of company who are not yet very familiar with merger control, they don't understand why they have to notify a deal. just because for them there's no competition issue. And the moment there's no competition issue, well, there shouldn't be any reason why the deal should be notified. Just don't get the fact that when it's compulsory, just because of your turnover threshold or market share threshold or value of transaction, you just have to do it. And just to make that point, in 99% of the cases, here I'm referring to the EU, 99% of the merger filing are cleared in a phase one. So you notify because it's compulsory and your deal is cleared. Of course, what we hear are all the cases where either the deal is blocked or the commitments are so severe that, well, the deal is hanging or withdrawn eventually. But so, one, when we advise clients, and you were talking about Bulgaria, you need to do this desktop analysis. You need to know where are you active, where do you derive turnover, where do you have assets, and where does the target sell to, into, what are their assets, what is the value of the transaction, and based on these numbers, then you can start and say, okay, Albania, merger control, what are the threshold, cross, not cross. So you do a brief analysis. And then you say, okay, you have to notify in these and these and these countries. Business will just get very mad at you because why do I have to notify in Bulgaria? I give you an example. There was this transaction some time back. It involved the Malaysian sovereign fund. And it was investing in a joint venture with a very big Japanese corporate. And they were investing in a joint venture which basically managed some real estate project in some state in Malaysia. So far, no problem. It had to be notified to the European Commission. Why? Only because the Malaysian sovereign fund and the Japanese corporate had such a turnover in the EU that they had to notify. There was zero impact on competition in Europe, zero. It was a real estate project in Malaysia. But it had to be notified. It went under a simplified procedure. It was cleared in 3 weeks, but it had to be notified. If it hadn't been notified, well, they could be fined because they have not notified, and you can be penalized for this. So when you advise clients, you have to do this desktop analysis. That's one. And you better do it early, because when you have to notify, and that's another point that comes up from time to time, is this use of notification. Say, okay, you have to notify the competition authority. Just tell them. But that's not what notifying is. A notification can be a 1,000 pages file. You have to give a lot of information. You have to define your market. How does the market work? Who is on this market? What are your market share? Who are your customers? Who are your suppliers? So you have to provide a lot of information, and that takes time. And it's amazing how you find out that some information is in one department and another part of the same information is in another department in the company. The data doesn't tally, and you as a lawyer are looking at numbers and say, hey, there's something wrong there. So it takes a lot of time. And then you have to present your case. So you're building a story. You're explaining to the regulator who you are, who's the target or your partner, and why what you're going to do is going to be a great venture and will not have or pose any threat to competition. If you think that there is some competition issue, you also have to deal with it in advance. You need to plan ahead. What could be the commitments that are going to be required? How do I put that, include this in my SPA, in my documentation? How do I value the risk? So we're talking about breakup fees. You also have, we had a case recently that was eventually notified and cleared, no issue. But we really had genuine questions on the market definition. And we thought the market definition was rather a broader market. But if it was going to a narrow market, then in one market that could be a problem and divestment requested. So there were days of negotiation in the SPA because the buyer was saying, I'm not going to pay for this product if at the end of the day I have to divest this part of the business. So how are we going to factor it in? And if I put too clearly in the SPA that I foresee that I'm going to have a problem in this market and that's how the value is going to be lowered, then the regulator, when they look at the SPA, they will know exactly what our thinking is. So how do we manage all this? So it takes a bit of thinking and it takes a bit of time. And because, coming back to your first point, parties are impatient to close the deal, first advice is think of it even before you start discussing the deal with the partner or the target.
I have a suggestion here on this. Normally, invariably, I found that the market information, what we rely upon, it's not perfect, it's incomplete because it is coming from different sources. And since it comes from different sources, there is the validity of that data is always under question. So normally, what we do, or normally organizations do, that engage multiple advisors and who would be giving that analysis differently in their own perspective. And finally, you get a good grip over the data in terms of what market we are talking about, what relevant market we are talking about, what is the market share, what would be the future scenario, which all are the players, etc. So I think the complete information, complete information is not available. Engage with multiple people, multiple announced people, as well as the couple of advisors, and not go with only one advisor. You will at times get strange results as well. Yeah.
So what in terms of substantive analysis, what we see that works really well, at least from the competition commission's perspective, is because there is this inherent distrust of lawyers, is to have somebody as an expert to come and have a chat with them, or the industry expert, to say this is what is important, this is what you need to look at from an industry perspective, and from that perspective. But going back to Dominic, when you're still thinking where to notify, and not at the substantive analysis part, but where countries I need to look at, sometimes the desktop analysis is not enough. And the Uber Grab example in the ASEAN countries is an example where it came as a shock to most of the antitrust world to say that could now regulators start looking at transactions even when in the absence of merger control. So if this was your home jurisdiction, so if you could give us more insight into that transaction.
Okay, so Karan was very kind because I said, do you have Grab in India? And would people know about Grab? So I understand you have Ola. So basically the Grab-Uber deal is like if Uber and Ola were merging. In this case, it's just Uber exiting Southeast Asia and selling its assets, plus there was some share participation. So eventually it was decided that it was a merger. It can still be discussed, but anyway, it was a merger. And it impacted various countries in Southeast Asia, including Singapore, the Philippines, Vietnam, and Malaysia. And so Singapore, you have a voluntary merger regime. You don't have to notify. And you have to do your own competition analysis. And so you do this with economists. It's not the lawyer, just trying to find out. You work with economists. You effectively have reports. You, of course, discuss with the business, because at the end of the day, people who know best are the business people. They know what they're doing and what the market is, and they have a sense of it, a very good sense of it. Which is why competition law is so nice, because you learn the business. So Singapore didn't have to be notified. But in Singapore, it's good, it's voluntary, but if the regulator thinks that the merger led to a substantial lessening of competition, they can investigate. They will investigate, and in this case, they did investigate. There are no timelines for the investigation. It can take a month, a year, and at the end they can issue what they did in this case, commitments, penalties, financial penalties on the parties. And while they were investigating, they issued interim measures to prevent Grab algorithm to be amended, so basically to try to have a competitive situation that was the same with and without Uber within the picture. So that was Singapore. Then the Philippines. Philippines, it's a mandatory notification country, and you have notification thresholds which are based on assets, value of the transaction, and turnover. The thresholds were not crossed. So fine, no obligation, no need to notify. And yet, the regulator said, okay, I'm not going to penalize you because you have not filed, because you didn't have to file. But on my own motion, I can investigate your merger because I think it had an impact on competition. So that's what they did. Similarly as Singapore, they issued interim measures, or there were some commitment provided. They fined the parties because they did not comply with the commitment they had put in. They reviewed the transaction. Eventually, they cleared the deal. But again, it took time, and you had these interim measures being put in place while it was reviewing the transaction. Vietnam, you have to notify based on market share thresholds. And market share threshold is very difficult. What is the relevant market? And for Uber, Grab, the question was, is public transport a substitute to this type of ride-hailing platforms, et cetera, What about the relationship with the drivers, exclusive agreements? So what happened in Vietnam is, again, it was not notified because Uber and Grab claimed that the threshold were not met. The competition authority disagreed, investigated, came up with the conclusion that this is the market and it had to be notified. It went to the VCA and so the VCC, so you have the Vietnam Competition Authority and the Vietnam Competition Council, who throw it back to the authority, say you need to investigate more, so it's still pending. So you have this, and in Malaysia, no merger control. So they were looking at it and said, what can we do? Can we say it's an anti-competitive agreement? They could have done this. After all, it's an agreement between competitors, but they thought it was a bit risky to go down this route. So what they said is, okay, now Grab, you are dominant in Malaysia. That's how we see you, so be very careful because whatever you do, we can go after you for abuse of dominance. So that's a deal that really went terribly in all these jurisdictions. Now, had the parties, so Jay was here yesterday, had the parties anticipated this? Maybe, maybe not. So in Singapore, one thing that really, really annoyed the Competition Commission was that there was a clause in the SPA saying that if financial penalties are imposed on us because we are found to have violated the Competition Act, so it was not said in so many words, but basically that was, then one party is going to indemnify the other, or both parties are going to split 50-50. So the Commission was, you knew there was a problem. And you did go ahead, you didn't notify, you went ahead with your transaction. This is proof that you knew it was bad. So you can plan the consequences, you can deal with them in your transaction documents. You have to be very careful in the way you deal with them and not to be caught, or you need to be clever in the way you deal with them. So that's an example, interesting example.
Yes. Thank you. And I think the problem with younger jurisdictions, including India, and if I'm apologies for using the expression, but they are all Me Too jurisdictions. They look at what the other jurisdiction is doing and they want to follow it in their own. So the risk that Uber Grab brought into India was that India looking at other countries, younger jurisdictions like itself, and saying, okay, those transactions may not be notifiable and therefore may not need approval from us, but we have this lovely provision called Section 3.1, which is to say any agreement in which is likely to cause an appreciable adverse effect on competition is this tool that we had. We didn't realize it, and maybe we can use it the next time something comes up. So Uber Grab is also an example of new technology companies, very well funded, and some may have common shareholders, and that is something which has now caught the imagination of competition regulators across the world, Shashank, where they think that maybe these cross holdings could potentially lead to softening of competition, even though they may not be a proper merger. So, and those transactions, when are filed, are now increasingly being scrutinized from that perspective. So, and as advisor to a lot of the private equities, how do you go about it, and especially when there's lack of clarity from the CCI whether or not those transactions are notifiable in the first place?
Okay, so but before that, I'll just jump on the chain of thought that you started with a 3.1 can, whether any merger, can get exposed, like suppose if it is not a notifiable transaction, or even if it has been notified and cleared, and I see it all the time. They would like to, clients would like to push some documents, just get it blessed from CCI. Now the thing is, like, there is nothing under Section 5 and 6 which entails like blessing, like if the CCI has seen it once, that means that it is kosher. No. CCI can still go into look under 3.1, and they have early in their regime, they had done that, the JV and Starden JV. They had tried to go into that direction. It's not like they will be doing it all the time, but it is quite a possibility that they can do. The question is whether what kind of animal it is, this catch-all thing, that is a separate discussion. The second part, what you said, is about the private equity investment. And in our filings, we see it all the time that CCI is trying to look into the common shareholding, interlocking directorships, to identify control as well as identifying the flow of information, because information and data is king, especially if it is e-commerce industry or industry where even a little bit of information or the sharing of information, coordination of activities can have some benefits to identified individuals or groups. In that kind of situation, CCI is actually looking into not just the portfolio companies who are present only in the market, which is subject matter of notification, but also all your portfolio investment. Their response to that, when we try to talk to them, that why are you asking this? The response to that is, we are the regulators, we regulate the combination, we will decide whether or not there is an overlap. So you give me the entire laundry list and we will do the simple analysis, which makes it really challenging and difficult for a lawyer and as well as for the private equity to do their notification. Whether and that comes from the first part that I said, that is the investigating risk. How much do you want to disclose? Are you really comfortable that if you are doing a 5 million deal, unfortunately because of the threshold requirement, it became a notifiable transaction, but still you have to disclose all sort of thing. So interlocking directorship is a big concern, because the information right can propel companies, and if it is the information is living somewhere in a particular fund somewhere and they are coordinating activities, then it can become a huge concern. And I can understand CCI's concern about it, but that is why when the private equity funds, or even I would say large group, if they are nominating directors on board of different company, and especially if they are in the overlapping scenario, or even if in the vertical relationship, they should try to avoid interlocking directorship. They should have sort of a ring fencing or a whole separate, not whole separate exactly, but a ring fencing around their directors, around their nominees.
Thank you. Dr. Ganawat, you've seen the CCI in the last 10 years, both from the behavioral side, which is Section 3.4, as well as 5.6. And one of the first interesting cases of divestitures was the DT PVR transaction. So from then, there is always this constant shifting sands of as far as the substantive analysis is concerned. So because we're running out of time, where would you like to see the next 10 years of merger control to be, or in terms of how the CCI approaches a case in terms of both looking at competition, potential competition, and the standards that they apply to determining where does relevant market stand and in market shares?
I think very good question, Karan. Two things. One is, I would say that as far as CCI's track record is concerned, largely, as far as Section 5 and Section 6 is concerned, largely they were reasonable. Their approach might be wrong, and which we can certainly talk about, and which would give us a visibility how they should go in the next 10 years. But largely, 5 and 6, their track record, industry perceives it's good. They have largely given approvals and all that. Section 3 and 4, I think they always tried to show their teeth, and they were wrong in terms of those orders. Now, as regards the future part is concerned, I think that there needs to, a shift is required in terms of the approach of CCI. And why I say the approach of CCI, all these issues, whenever they come to CCI, CCI only sees that from a lens which a particular official would be seeing in terms of his perspective, whether that proposal is right or wrong, and what is the criteria for seeing that proposal is only market. So they are using the means to achieve that end, and is the ultimate consumer, the beneficiary. Now, without thinking about that beneficiary, they keep on giving orders based on this relevant market criteria, and which, to my understanding, is completely wrong, because relevant market criteria might be relevant as far as European jurisdiction is concerned. But then in a situation like India, vast country, I think the relevant market criteria would have so much subjectivity, there is no objectivity. Every time each proposal would have a different dimensions and interpretations, and even the industry players would also be furnishing the information based on what suits them. At one point of time, if a North Indian market would suit them in terms of 5 states, they would include 5 states. Else they would include 1 state. So there is no objectivity, and subjectivity is to that extent that you can maneuver the figures and based on how you want to project your case. So I think that the big shift which is perhaps required in terms of criteria and parameters, which CCI should be seeing in the times to come, from the perspective of, that should be seen in the perspective of the beneficiary, the ultimate beneficiary, and not these market kind of concepts. I think largely, I think this is how I would be looking at the CCI's functioning. As regards the other Section 3 and Section 4 is also concerned, I think that there's a complete shift is required, because for example, the cartelization. Now, I normally say the cartelization, even if the industry players are not cartelized, the government of the day or the state government would force them to cartelize. If the chief minister calls the industry players and say that you reduce the prices of this particular product, whether the industry players would be saying no to that. The answer is that the cartelization is happening through the government participation as well. I think that those concepts need to be changed, and the CCI should be looking all these issues from a different lens, rather than the traditional lens which is dictated or mandated by the European orders. I think that shift perhaps would be required.
So, Dominique, as you know, we're talking about globalization in terms of trade, and there is a lot of talk about globalization, harmonization of competition standards across the globe. But they, as the point made by Dr. Kimawat, is you have to see local conditions and adapt to those local conditions. Now, what's important is also we're hearing a lot about public interest and nationalism, which is coming into the antitrust debate. We've always had countries like led by South Africa and the African Union, where you've had commitments which are not, which are to secure employment, to sort of undo the apartheid and the likes. But that is also coming. The UK recently blocked a merger because because under the Enterprise Act, they're allowed to do so in case of there was a Chinese company trying to buy some wireless telecommunications in the UK. But that's also goes sort of contrary to what happened in Siemens Alstom. So, not as a competition lawyer, not as somebody who's in ASEAN, but as someone who's born in France, what I would like to just, what was your views on that?
Okay, so as a French person and only in my own name, yes, we're going to be quick. So we discussed this. First, this is an EU decision. EU is 27 countries. So when you talk about national public interest, of course, you have 27 national public interest. It's not the role of the EU to go into this national public interest. But the question here really was, and there have been a lot of discussions from years ago in relation to national champion and so within the EU, and when there were mergers which were blocked or some commitments provided, and between member states, and saying, hey, but European Commission, you have to let us have national champion because it's important for our country, etc. Never worked at the European level. Now, the Siemens Alstom, I think, is interesting because it's not, well, there was an impact on some member states. So the European Commission point is to say, look, if I allow this merger in a number of member states, there were two players as will only be one. So that's it. The response by Siemens and Alstom was competition, especially in what we do, is global. And we need to be able to compete against Chinese in particular. And we need you to help us to do this. So it's an ongoing discussion. It's a political discussion.